fastest time. We left this place at some minutes past midnight. Went, we retreated. Some of us are based elsewhere, not in Mombasa. So we have to make space to prepare grounds of position, which we have. And they observed with the authorities. The view was in 2 minutes we are serving grounds of position.
The circumstances of the case dictate that he checks. So we have that. He has our responsibility. The court also has our responsibility.
I don't know what to that. I'll give my application. We have two individuals here, one is Lily and Alison, who are seeking to be enjoined in this proceedings. Filed an application dated the 24th of June, and the same is supported with an affidavit and buttressed by the following submissions. My lady, my lord, the applicant seeks to be enjoined on the basis that they had previously filed a petition number 2E230 of 2022, which was a petition between the applicants. Yes, okay.
We need details about number 232. Where was it filed?
Yes, yeah. The same was filed in money. Constitutional petition number E230 of 2022, which was a matter between the applicants herein and one Mike Sonko. The same, my lady, was dismissed by the jurisdiction. The ruling was delivered, a judgment was delivered on the 4th June 2022 by a three-judge bench. With that as it may, my ladies, my lords, it therefore follows that the petition that the petitioners had filed was not disposed of on merits. Ladies, my lords, what were the issues that the petitioners, the current applicants, were seeking for determination? One, my lady, my lords, in that petition, the petitioners were seeking for determination of an issue, whether or not, while interpreting Article 193 of the Constitution, the court ought to lay emphasis on 6 solis of Article 59. That was the first issue. The second issue, whether or not, the first issue was whether or not, while interpreting Article 193 of the Constitution, same ought to be done in accordance with Article 259. The second issue, was whether or not the rights under Article 38 are limited by virtue of the successful application of Article 181 of the Constitution. Article 181 being the article that commenced the process of removal of the petitioner in this matter. The third issue, my ladies and gentlemen, was whether or not the petitioner's rights acting in the public interest as exposed by Article 22 proceed supersedes the rights of the respondents under Article 3.3. Whether or not the petitioner's rights under Article 22 proceed of the Constitution supersedes the rights of the petitioner herein under Article 193. Number 5, my ladies, my lords, of the issues, because these issues will lay the basis and the stake. Whether or not a person is found in accordance with the law to have violated the Constitution should enjoy the same protection under the law. Of course, my ladies, my lords, we're looking at Article 75. The sixth issue that the petitioners were seeking
Okay. Someone came to back of the conversation. I came here to see that the petition is conducted, and I'm ready to go on the way. There are some petitions that are coming now before. We want them to get the impression that these applications are for IEBC. And they just intend to waste the time. We want to make a result. We want the petition to pass. And we are saying that we have got the discretion to stop some of these applicants from wasting the court time.
Yes.
The sixth issue was whether at 183, these issues I am raising are the ones that are raising the basis of the identifiable stake the applicants have. And these are legal issues.
My lady, may I just listen? We are all officers of the court. What we ought to stand here to tell the court without wasting time to come here to try and say is what stake, what direct stake he has, what prejudice he will suffer. All those other things that he's talking about are what has brought us here as petitioners. He cannot usurp the role of the AG at 156. It is only the AG that can come in that way. Otherwise, he cannot just come here and tell us that they are the ones who know how to argue cases in court. We are here as parties and less as parties. Yes, sorry, my lady.
So, my lady,
Why they should be joined?
yes, my lady.
Why we should
Yes, my lady.
you are planning to join?
I will fight that petition, my ladies, my lords, that the applicants have an identifiable stake. And if you look, my ladies, my lords, at the judgment that has been served upon us by the respondents, there is a question of what is an identifiable stake. Is a legal interest an identifiable stake? And if there is the legal interest is an identifiable stake, should the prejudice suffered by the applicants be personal, or it can be a prejudice that will be suffered by the close sectional of the society? But in answer to that question, I defy you to look at Article 3 of the Constitution, that any person has a right to protect and uphold the Constitution and even protect it from abrogation. On the basis of Article 3 of the Constitution, the applicants fight solace. The other identifiable mistake, my ladies, my lords, is that under Article 43 of the Constitution, 48 of the Constitution, my ladies, my lords, pardon me, the applicants have a right to access this court. And therefore, my ladies, my lords, the question for determination is whether the issues the petitioner, the applicants are raising, as illustrated in the court this afternoon, were substantively determined that under Article 48 of the Constitution, the applicants fight solace. And therefore the question is whether the issues they addressed in petition number 2E230 of 2022 was substantively missed, was that we had moved to court prematurely. We had jumped the gun. As we are, my ladies, my lords, as at now, the IEBC, that's the first respondents, have dispensed of their jurisdiction by hearing the petitioner, declining his nominations, and therefore the petitioner has moved before you. And these are the proceedings which we are therefore seeking to be enjoined with. Further to that, my ladies, my lords, it is essential that we distinguish the proceedings before the IEBC and the proceedings before you. To the extent that the proceedings before the IEBC were proceedings in persona, they only related to Governor Sonko. And as such, the applicants herein in this application would not have necessarily or ordinarily joined in those proceedings. They did not have a stake, they did not have locus standi for the IPC. And therefore, my ladies, my lords, we submit that upon the complaint yielding to the current petition, the proceedings happens to be in rem, and therefore if they're in rem, it opens an opportunity for the applicants to approach you for enjoyment. And therefore, the test of prejudice to be suffered should not be a test that will be applied in personam. It should not be the prejudice of the applicants alone. But the applicants must be viewed in light of Article 22 of the Constitution. That they are here to protect public interest. And therefore, the stake has been expanded, the scope has been expanded, that warrants the enjoyment. Finally, my ladies, my lords, The Supreme Court, in the case that has been served upon me, that is the Attorney General versus David B, number 73 of 2021, the Supreme Court looked at the question of personal interest or stake that the party had in the matter and had to be set out in the application. That is Supreme Court number 73 of 2021. My ladies, my lords, as I sum up, I invite you to look at the Mutunga rules and look at the definition of an interested party therein. It has defined what an interested party means. My ladies, my lords, permit me to look at it. It has provided that it means a person or an entity that has an identifiable stake or legal interest or duty in the proceedings before the court, but is not a party. So there are three elements here. The first one is identifiable stake. The second one is the legal interest. And the third one is the duty. Do the applicants have a duty? Yes, they do. Which duty? Under Article 10 of the Constitution, Article 3 of the Constitution. Because when you look at Article 3 of the Constitution, my ladies, my lords, on the question of the protection of the Constitution and the protection of its sanctity, that is where the crux of the matters are. That the applicant wants to demonstrate to the court the implication of Article 181 to the current petition. Vis-a-vis, and I'm summing up, vis-a-vis Article 193 Clause 3 as read together with well, as read together with Article 75 of the Constitution. Again, the legal interest has been expounded in my submissions. That other than protecting the Constitution, seeking the court guidance on the scope of application of Chapter 6 on leadership and integrity, and most importantly, Section 10 of the leadership and integrity, Section 11 plus paragraph A to B, Section 12, Section 13, subsection 1, paragraph A, B, and C, and D, and E of the Leadership and Integrity Act. That is the legal interest in all these matters. The application is not motivated by malice nor ill intent. It is merely created to ensure that the rule of law is upheld and the provision of the Constitution reigns supreme. Much obliged.
Your Honor, may I pose a question before I speak on the Kenyans? You really want us to speak and waste your time.
My ladies and